It's going, and I'll start the recording. Right, that's you up and running.
Good afternoon. It's time for us to make a start. My name is Dan Jackman, and I'm the reporter appointed by Scottish ministers to carry out an examination into the planning appeal against the refusal of planning permission by West Lothian Council for the erection of 104 houses and associated development on land at Hens Nest Road, East Whitburn. The purpose of this meeting is just to discuss the procedural arrangements as set out in the circulated agenda, and I will not allow any discussion of the merits of the cases. Can I ask those of you who are intending to be the main spokespeople for their team, if you could keep your video on but mute yourself, unless of course you wish to speak. If you're here in an observational capacity or only likely to speak if you were called upon, then if you could turn your video off. As I go through the agenda, I will be directing questions at the parties, but if you want to attract my attention, if you could wave vigorously rather than use the hand box, the hand sign on the chat box, because I tend to miss those. A very important person that I need to introduce is Morag Smith. Morag is the case officer for the appeal and is responsible for maintaining the file and undertaking all the administrative arrangements on my behalf, and through whom you should go if you have any queries or you need to contact me. All the case officers are working at home at the moment, so that would be via email in the first instance. Morag happens to be on leave for the next 2 weeks, but her inbox is being monitored by other case officers, so things will be answered. I shall be keeping a note of our discussion this afternoon, and certainly will circulate a note of the key decisions that we make as soon as I can this week. The note of the meeting should be treated as a procedures notice under the appeal regulations. That's all I had under item 1. If we could move on to item 2. In any planning appeal, the main parties will include the appellant, whose appeal it is, and the council, who is the planning authority, and has various statutory obligations placed upon it. So if I could start with the appellant's team, perhaps you could introduce yourselves, please.
Thank you, sir. My name is Alistair Sutherland, and I'm a partner with Burness Paul Solicitors. I'm representing the appellant, Ogilvy Homes. Also in attendance for the appellant, we have Ross Johnston, who's Technical Director, Ogilvy Homes, and Julie Lease, who's Land Manager with Ogilvy Homes, and also Bob Salter, Callum Glenn, and Rob Miller, who are all with Geddes Consulting, who are the agents for the purpose of the appeal. And those persons are the authors of the statement of appeal and the various supporting statements that were submitted with the appeal. And lastly, Miss Lee Houghton, who's landscape architect with Brindley Associates, and she is the author of the landscape and visual impact assessment that was submitted as one of the supporting statements for the appeal.
Okay, thank you. And for the council's team, perhaps you could introduce yourselves, please.
Thank you, sir. My name is Tony Irving. I'm Principal Planning Officer in Development Management, and also involved in this appeal for the council are Marlon Fatua, Senior Planning Officer, who is the case officer for the planning application, and also Steve Lovell, who's Principal Planning Officer in Development Planning.
Okay, thank you. We also informed everyone who made representations on the original application, and Mr. Hogg indicated that he wished to participate. Mr. Hogg, I wondered if you would turn your video on and introduce yourselves to the meeting.
Hi, Alan Hogg here. We're residents on the face of Hens Road, and obviously the proposal would be a huge impact to us, being literally 20 feet from the front door. So quite keen to understand in greater detail what the plans were and what the proposals are going to be.
Okay, thank you. Mr. Hogg, you'll notice during this meeting that I'll direct many of my questions to the appellant and the council, because normally they have the most to say on procedural matters. Don't think that means I'm ignoring you. And I always check before I move on to the next item on the agenda. Item 8 on the agenda is an opportunity, if you wish to take it, if you had any questions of me about the process, etc.
Okay, thank you.
Right, if we can now move on to item 3. I set out in the agenda and the annex to that my provisional view as to the further procedures that I think I need in order for me to make my decision. I should just say that the fact that I've included conditions and obligations hearing sessions does not mean that I've made up my mind. We have to discuss conditions and obligations at this stage in proceedings in the event that I allow the appeal. This is completely normal and standard practice, and I fully accept that any discussions we may have on conditions and obligations would be on a without prejudice basis. The appellants sent round some preliminary thoughts on my suggested procedure. Perhaps I could start with the appellants, whether you wanted to expand on that or had any other comments you wanted to make about my suggestions.
Thank you, sir. I think the appellant's position is really set out in the email that was sent to Ms. Smith. But I mean, perhaps if I can just, for the benefit of everyone on the call, really just summarise what the appellant's position is in relation to further procedure. I mean, there's really, I think, two key issues or two matters that direct further procedure. One is the issue of 5-year housing land supply. So I'll deal with that first, and then the other is the other issues in the other proposed hearing sessions. I mean, firstly, in relation to 5-year housing land supply, clearly and respectfully, it's a key issue in the appeal, whether there is or is not 5-year housing land supply. Informs the policies that apply, and it informs the approach that needs to be taken to the wider policy framework and ultimately determination of the appeal. The problem, if I can call it that, or rather the matter that has arisen, is the change that's been brought about by the recent court decision, which quashed the amendments to Scottish planning policy and quashed Planning Vice Note number 1 of 2020. And I think that would be an issue which parties, I should say actually just for completeness, that obviously occurred after parties had submitted a statement of appeal and after the council had put in its response to the appeal. So it would be a material consideration, a new consideration, if you like, that parties would need to deal with anyway. But in this case, in particular, the council's reasons for refusal and the council's response to the appeal are both predicated on SPP 2020 and Planning Vice Note 1 2020, which obviously now have gone. So the effect of that in terms of understanding parties' position in the appeal is that, well, certainly from the appellant's point of view, I think also from your point of view, sir, is that we don't really know what the council's position is now on the application and in response to the appeal. The appellant submitted, in any event, in its application form for the appeal, that a hearing session on 5-year housing land supply would be required, or at least that was what the appellant suggested in its appeal form, and that may still be the case, and indeed it's likely still to be the case. However, going straight into hearing session on 5-year housing land supply, I submit would be difficult and could be complicated and quite frankly difficult for yourself to actually deal with in the absence of some kind of prior procedure where the council explains what its position is now in response to the appeal, and with the appellant having an opportunity to respond to that. So that's sort of the thinking that's led to the appellant's principal suggestion for further procedure, which is that instead of going straight into hearing sessions on the issues set out in your agenda, would be to have a procedure notice requesting that the council does comment on the effect of the changes to policy and the recent court decision, with the appellants having an opportunity to respond to that. So effectively written procedure. In relation to the other proposed hearing sessions, as the appellant explained in its email to Ms. Smith last week, the appellant took quite a detailed approach to the submission of the appeal, which included a detailed statement of appeal and detailed written supporting statements on the relevant issues. The council hasn't responded in any great detail to those supporting statements, and it's the appellant's position that really there is enough information before you to be able to determine the appeal without having to have hearing sessions to discuss the various matters. If you do consider hearing sessions and other topics are necessary, then the appellant's position is that there would need to be some process for actually focusing in on really what the issues are that are either in dispute or are unclear, or which you, sir, would wish to discuss at the hearing sessions, so that the appellant and the council really can focus on what would need to be discussed, and indeed can actually estimate how long will be required, because as matters stand, I think really the appellant would just be submitting the supporting statements as hearing statements, without any real understanding of exactly what are the issues in each topic that requires to be discussed. But perhaps we can circle back to that after we've heard from the council.
Yes, I wasn't anticipating going straight into hearings. I would be looking for hearing statements, so that the parties would see what each other was saying well in advance of the hearing itself. And then I would prepare an agenda based on those hearing statements, which I would try and get out 2 weeks before the hearing itself. And yes, I completely agree. There's actually no point talking about stuff that there's no dispute. In my head, I was thinking that these would be, if you like, either 4 mini hearing sessions or one big one in 4 parts, because they seem to me to be all interrelated, in the sense that policy sets out the principles for land supply, and your detailed submissions were put on to help me or help the decision maker interpret the policies, and of course conditions and obligations also flow from policy in terms of what's necessary to make a proposal acceptable. But we'll come back to that. Let's hear what the council has to say. If I can ask, I'm taking that Mr. Irving is the principal spokesperson, so perhaps you can let me know what the council thinks about my suggestion.
Yes, thank you, sir. The council would be content with the approach that you've just outlined. We don't have any concern with submission of hearing statements. I'd agree with the council that it would be helpful in terms of the apart from housing land supply, the other three subject areas to know exactly what the concerns are. I think you've alluded already. There'll be maybe a series of questions set out to focus on what the main issues were. In terms of the 5-year housing land supply, again, the council would be content to set out its position following the reduction of revised SPP in PAN 1 2020. The council is just doing that at this very time in relation to another appeal which concerns a similar greenfield site in West Lothian. So I think in summary, the council would be content with the process which you've just outlined.
Okay, thank you. Mr. Hogg, any thoughts or comments?
Not at the moment, no, thank you. Just obviously waiting to see what the process will be.
Okay, thank you. Well, I wonder. I wonder if it's helpful if I just went through my Annex 1 and just indicated what the sort of things that I was after, and that might give the appellant's team some comfort. So, I mean, obviously, hearing session 1, everyone knows that I have to make my decision in accordance with the development plan unless material considerations indicate otherwise. So I am looking for the parties to identify what particular policies they think are relevant and whether they comply or not. There are interesting issues about what that means where you have a plan which has less than 5 years to run. Obviously, in terms of material consideration, I'm sure you're going to refer me to SPP 2014 and the associated court cases, and I think I need to know your positions on that. In terms of the housing land supply matters, there's two sides to the equation. There's how you should calculate the 5-year requirement, and everyone will be familiar with the various debates that have been held in over this matter over the years, but also how you know what supply is provided. I would also want to make sure if I was going in to write a decision that I was clear on the data and sources, and if there were any differences, that if they couldn't be resolved, that I understood the reasons for those differences. In terms of hearing session 3, then there were 4 submissions from the appellant, which were aimed, in my opinion, but I'm happy to be corrected, at helping the decision maker interpret the various policy frameworks as it applied to the proposal. I had various questions that I wanted to ask about those things, both of the appellant and the council. And that's something that I can highlight in the agenda. And there were various design and layout considerations that appeared to me to crop up from the consultation responses that it would be useful to sort out. And in terms of the planning obligations conditions, there does seem to be a measure of agreement. There's not complete agreement between the appellant and council, and these things are often just best discussed. So for the appellant, does that give you any assurance at all?
Thank you, sir. It does help. So it certainly does. So I'm very grateful, and certainly I hadn't anticipated we or rather I wasn't under the misapprehension we'd launch straight into hearing sessions without any further direction. And certainly having a clear agenda for the proposed hearing sessions in advance of parties preparing exchanging hearing statements would help, so that we can understand under each proposed hearing session what it is, sir, that you're really looking to discuss, so that we can focus our hearing sessions.
Yeah,
Hearing statements rather.
we have a slight chicken and egg problem here, because I would normally base my agenda on the hearing statements. It's really for the parties to tell me. I try really hard when I come up with the matters to discuss at hearings to indicate the areas that I feel we need to discuss, but at the same time not be so detailed and specific that I'm constraining parties in directing them in particular areas. And I did my best to strike that balance. I'm hopeful that a combination of Annex 1 and my explanation would that give you enough to write a hearing statement. I also add for the appellant's team that you're quite right. You have already given very extensive submissions, and it may well be all you have to do in terms of answering these matters is just signpost me to that point. So in terms of the settlement and local character assessment, you have set out the conclusions, and perhaps that is all you need to say. But I'm giving you the opportunity, if you want to say more.
No, that's I appreciate that, and I think that comes back to the point I was making, that probably is the approach the appellants will likely take, and it's helpful to have your direction on that, because I wouldn't want the appellants to appear to be unhelpful if that's simply all we did, without actually looking to really home in further, because as I said previously, on the one side there are the appellants' very detailed written statements on these matters. On the other hand, there isn't much detail, if any at all, from the council. So it's difficult for the appellants really then to say, okay, well we can readily see exactly what the kind of the issue in dispute is in relation to these issues. But certainly the appellants have got no difficulty with taking the approach suggested, and the only slight issue which I'll come back to is one of timing, but we can come on to that in terms of how long might be required for the hearing sessions.
Right. Yes, we'll come on to that and the next item on the agenda. So I think we've reached some kind of an agreement. So if I think we'll run with my suggested further procedures. Now that I've explained a little bit more my thinking, and what I would be looking for is for hearing statements to be submitted, and then I'll be formulating the agenda, and there'll be time for parties to know what it is that I'm actually looking for, and I am expecting it to be a fairly focused hearing session. I'm not anticipating a long session, and because it will be, well, I'm proposing a virtual hearing session, then I will probably give more detail in my agenda than perhaps I would have done if it was a live hearing session. And so so that's what I'm going to be proposing. If we can therefore move on to item 4, having had that discussion, we perhaps can cut to the chase. So my strong preference is for a virtual hearing session, and I've previously circulated a time of 25th and 26th of October to hold those hearing sessions. I may have been a bit overly cautious in thinking it would take 2 days. I think it's quite possible for this to take a day, but it's better to diary too much, which we don't need, rather than have it the other way round. So for the appellants team, any thoughts on the format and the dates?
I'm afraid, sir, I've been slightly taken by surprise by the dates. I wasn't aware that there had been dates proposed for the hearing sessions. I wonder if I could just I'll contact the appellant's agents just now if Sarah could perhaps come back to me, and I'll just check the availability for those dates.
Do you want to recess to speak to your colleagues?
I'd be very grateful for that. Just I think 5 minutes would be enough just for me to make contact.
Okay. I'll tell everyone to stay on the call, but mute yourselves and turn the video off, and we'll come back on at 14:37.
Thanks, sir. Apologies, sir. I'm just I'm about 90% of the way there. I'm just checking one more person's availability. So should hopefully just be another minute or so.
That's fine. That's fine. Okay, are we ready to reconvene?
Yes, sir. Firstly, apologies again for that.
No problem. Can I just check that we haven't lost Mr. Irving, that he's... Yep, okay, cool. Sorry, carry on.
Thank you, sir. The Monday, the 25th of October is suitable for the appellants.
Okay, splendid. Mr. Irving, would that work for you?
Thank you. That week just can be some slight concern, simply being the council has council executive on the Tuesday, development management committee on the Wednesday, and full planning committee on the Thursday. There will be committee site visits, preparation, and probably I would see some of the personnel involved will have involvement on that. So my initial view, the 25th and 26th, I think could be problematic for the council.
Okay.
So it's just it's a pretty full week committee-wise.
Right, but okay. The constraint isn't me; it's the IT equipment. So if I was to offer you the 29th of October, Friday the 29th?
I think that is, without checking individuals' concern, but that certainly would get us beyond the committee days. So I think it would be more agreeable, yes.
Right, well, I hope we won't unravel being checked. But obviously, it's not easy to pick dates. Everyone's busy with various things. But for the appellants, does the 29th work for you?
Unfortunately, I'm not able to say so. I need to recheck dates with the appellant's team. I don't know, sir, if you perhaps provisionally want to fix that date, and then if we can agree it, then good, and if not, we can perhaps agree it by exchange of correspondence, or indeed I can check again just now.
I would rather if you check just now, if you can.
Well,
It'd be better to nail this down rather than to try and find another date once you're not in front of me. So I'm happy to wait. I completely
I'll do that.
understand why this is difficult, and every single pre-examination meeting I've ever done, fixing the date has caused problems, which is why I thought I was ahead of the game by circulating something in advance. But and if you didn't get that, then my apologies. But so if you can, if we'll hold another 5-minute adjournment while you do that.
Thank you.
Okay, have we got some results?
I do, sir. I'm afraid it's not the results that you're looking for. We can't, unfortunately, we can't do the 29th of October, but I have checked availability for the following week, and we can do the 1st to the 4th of November. So that's Monday, Tuesday, Wednesday, Thursday of the week beginning 1st of November. So we can do any of those days.
Okay. Mr. Irvin, how is the following week for you? I think you're on mute. I think you're on mute.
Apologies, sir. I think the following week, I think a day there. Yep, I think that looks fine from the council side.
Right. Mr. Hogg, what about Monday, the 1st of November?
Yes, sir. 1st of November is fine for us.
Bingo, we have a date. So if I will check with our IT team, but on the calendar I've got, then we're free. So if we make it Monday, the 1st of November, and we can make the Tuesday as a reserve if we need to. It will be obvious once I see the hearing statements if I don't think it will last longer than a day, and we can resolve that nearer the time. Okay, that's the dates and the format. If we can move then on to item 5. I'm assuming that I take it as read the appellant and counsel will be attending. Mr. Hogg, any thoughts on whether you'll be participating?
So yes.
Yeah.
Yes, we can certainly be there to participate. No problem at all.
Okay. Thank you for that. So if we then move into hearing statements, I would find it helpful, as we discussed previously in item 3, if there was either one hearing statement divided into 4 parts or 4 hearing statements addressing the matters I set out in Annex 1 as expanded upon when we talked about it there. There'll be no word limit for hearing statements, and as I mentioned at the time, I'm aware the appellant has provided extensive submissions, so please address those items in Annex 1, but it's perfectly acceptable for you to just signpost me to the submissions that I already have. For the council, you've referred me to committee reports, but again, as we've discussed previously, SPP 2020 amendment and the PAN have been quashed, and I would invite you to address those matters in the light of that court ruling. So hearing statements would be 4 weeks, required to be submitted 4 weeks before the hearing, which, since we've changed it from my notes, what we're saying the 1st. So that would be Monday, the 4th of October. And they should be submitted electronically, and I'll just come on to how that process should be dealt with under benefits, under documents. So for the, I know the appellant and counsel will know what a document is, but for anyone else listening or for Mr. Hogg's benefit, any publication, photograph, plan, map, research paper, other document that is supporting what you're saying in your hearing statement, that should be kept separately and submitted separately, although obviously that needs to be properly cross-referenced. Obviously, you don't need to submit again documents that are already before me. And I'm not seeking additional documents, but if you think they would help, then then that's fine. Again, they should be submitted electronically by the 4th of October. I suggest you contact the case officer in advance just to discuss the mechanics of that, particularly if you're going to be submitted very large files, anything over 10 megabytes. There are ways around it, but please discuss that with the case officer. Bear in mind that the DPA uses a Windows 10 system, so avoid file formats that would not be compatible. Normally, it would be Word and PDF files are submitted. If you're going to give me photographs, plans, or maps that it's necessary for me to read in detail in order to interpret them properly, and which I couldn't do on a screen, then if those could be submitted as hard copies, and avoid using web links in your statements. The problem with web links is that they will one day die, and there can be arguments over what has actually been submitted to me. So that means, in terms of time scale, hearing statements and documents, the 4th of October, and I will use my best endeavours to have the agendas out by week commencing 18th of October, and the hearing itself will be the 1st of November. Is everyone okay with that? I'm seeing nods. That's good. Can we then turn on to item 6? I would find it helpful for closing statements after the hearing sessions, just to wrap up all the points that we discussed. It's not compulsory, but I will make that option available to parties if they wish to do so. Again, I won't set a word limit, and we can discuss the timetable before I close the hearing on the 1st of November. If we can then turn to item 7. I have visited the general location of the site on an unaccompanied basis. I've been to each of the viewpoints for the landscape and visual impact assessment. I've walked the various suggested routes into Whitburn. However, I would like to satisfy myself and visit the site itself. You know, the boundary treatments, the culverts, and just to actually see the site as opposed to try and seeing it from the road. And I was wondering whether we could have an accompanied site visit, say the morning of the 2nd of November. Would that be acceptable to the appellants?
Yes, I think given the appellant's team's availability, I think that should be acceptable.
And for the council?
Yes, so that's fine for the council.
Okay, great. And it's not necessary for you to attend, Mr. Hogg, but if you wanted to attend, that would be, would you be available?
Yes, that'd be fine. Second.
Okay, thank you for that. Okay, that takes us to item 8. I'll start with Mr. Hogg. If you haven't been involved in pre-examination meetings before, that might all be rather odd and strange. I wondered if you had any questions of me about the process.
Not at this point, no. I mean, happily, I'll admit we haven't had much experience in this sort of event before, but kind of looking forward to getting involved and sharing our thoughts and feelings and learning the viewpoints from the various points around the table.
What I would say is other people in your position, you might find it helpful to speak to the council.
Yes.
There's no point if your position is entirely aligned with the council and just repeating what they have to say.
Indeed.
And what I think you might find helpful, and so I'll ask the case officer to send you a link to a webcast of another virtual planning appeal hearing, so you can understand what happens. It's not the same as a council planning committee hearing.
Right.
At a planning committee hearing, then that's an opportunity for people to address the committee. But in a planning appeal hearing, I ask the questions of the parties, they give the answers, the other parties present comment on those answers, and then we move on. So it's not for you to address me as such. It's for me to ask questions based on the hearing statement. And as I say, I think you might find seeing a webcast of a virtual one helpful. If you do have any queries or questions, then just contact the case officer in the first instance.
Thank you.
Okay. Is there anything else we need to discuss? Is it all clear? Everyone knows what they're doing.
Nothing to balance, sir. Thank you.
Mr. Irvin?
To mute again.
I take that as he's quite happy.
Correct, sir. Thank you.
Just a thumbs up will do. Good. That's the right sign. Okay. On that basis, then, thank you for that participation. We got there in the end. And I'll endeavour to get the note of this meeting out as soon as I can this week. And otherwise, the next time I see you will be the 1st of November. Thank you very much, and I'll close the meeting.
Thank you.